details associated with this. As a start, this will be more of an exploration of how township establishment can impact on the sale of a house in an existing suburb, both in terms of the steps that were taken prior to the proclamation of the township, as well as the steps taken after the proclamation of the township. The only technical detail that you need to be aware of for now is that the proclamation of a township means that after the township register was opened in the deeds office, it is declared an approved township by means of a notice that gets published in the Provincial Gazette. And this notice is called a proclamation notice. And the impact of this notice is that the land on which the township was established gets converted on that day into a township with stands, streets, and parks. I will also use the example of a house which is for sale in a suburb in Johannesburg to illustrate the impact, the direct impact of township establishment after the date of proclamation. I will also show how a basic due diligence can reveal layers of information about a property, all of which is required to make an informed decision before buying that property. I manage the Township and Development Conveyancing Department in STBB Sandton office. And I'm ably assisted by Amanda Seaman, Bernu Botha, Koketsu Tsebe, Ilza Engelbrecht, and Sylvester Makiza, together with a team of long-serving secretaries. And if they had something to say about this, they might say long-suffering secretaries. Please allow me a short commercial about the activities of our department so that we can get that out of the way and carry on with the real business for the day. Our department covers all aspects of conveyancing, from the easy-peasy transfers to subdivisions, consolidations, servitudes, street closures, legal research, advice on the disposal of title conditions for the purposes of township establishment, the opening of township registers, the opening of sectional title registers, the transfer of FISP houses, which are now known as First Home Finance houses, the transfer of bonded houses in housing developments, and a few other interesting property-related matters which are not the ordinary run-of-the-mill conveyancing. I know this is quite a mouthful, but if this did not convince you about the capabilities of this department, I hope that it at least confused you a little bit. Just something short about myself, so you know that you will not be wasting 30 minutes of your time today. I studied law at the University of Pretoria, which at that time was the biggest Afrikaans university in the universe. This university is situated near a very famous rugby stadium where the rugby supporters behave strangely. They wear hats with horns when they pitch up to support their team. After completing the BLC degree, I went to work at the Pretoria Deeds Office, which gave me exposure to all aspects of conveyancing. I started as a clerk in the general offices, became a junior conveyancer, then a senior conveyancer, and I left in 1989 to do my articles at Van der Walt and Ego Attorneys. During my time as candidate attorney, I met two town planners, Johan Hammond from Van Zyl Appel in the Kok in Middelburg and Paul Kotzer from Co-Plan in Alberton. And they had a huge impact on my career. Johan involved me with the formalization of many townships in the Mpumalanga province. These townships were established in terms of the Black Communities Development Act No. 4 of 1984. So it goes back a long way. And these townships were situated around towns like Middelburg, Witbank, Ogies, Amersfoort, and a few other towns spread over that province. This act was introduced in 1984 to provide for the purposeful development of Black communities outside the national states. What was interesting is that the people who occupied the stands in these townships had rights to leasehold in respect of their stands. The opening of the township registers for these townships automatically converted these leasehold rights into freehold or regular property rights. This work tickled my fancy. I became fascinated with the set of events which turns farmland into a township, where people can now occupy houses, they live there, and they can create new communities. This also fueled my passion for housing developments, which stood me in good stead when I later became part of major housing developments like Cosmo City, Louwfereng, Walwe-Vleerhof, Savannah City, and Leeupoort. Paul Kotzer, in turn, introduced me to an extraordinary township establishment challenge around an existing township. Don't know if you know where Colini is. It's a small maize farming town in the Northwest Province. When the farmers in that area grew older, they left the farms to their sons and daughters to carry on with the farming, and they then bought small pieces of land around the Colini Township, where they settled. This land was big enough to keep sheep, a cow or two, and to grow some maize, fruit and vegetables. So it was a little mini farming going on while they have the advantage of being close to the town. Soon about 30 of these parcels of land appeared around the town. What happened here was in effect an unofficial and illegitimate township establishment. And this situation had to either be stopped by the municipality or formalized. The municipality and the owners of these parcels of land eventually came to an agreement to include these land parcels as serviced stands in the Colini Township. A plan had now to be devised to implement the proper town planning, legal and conveyancing steps to convert these patches of farmland to stands that are depicted on the existing general plan for Colini Township. The solution was to extend the boundaries of Colini Township so that these land parcels can be added to the existing general plan as new stands. This required special permission from the Surveyor General because these new stands had to be added on the sheets of the general plan, but there was not enough space available. The deeds office also had to be convinced to process the 30 applications to register the incisions against the title deed for these land parcels. Sounds very technical, but an incision is the process where a surrounding farmland becomes part of a township, while an excision is where an agricultural holding gets excised and reverts back to a farm register. Okay, that's the second technical thing, but don't stress too much about that. When this process at Colini was completed, Colini was left with one very happy town clerk at that time and 30 new rates payers. This early exposure to these types of township challenges set me on the road to become a conveyancer who focuses on township establishment and developments, with a special emphasis on the legal and conveyancing process to open the township registers so that the townships can be proclaimed and the stands and sectional title units in the new township can be transferred as soon as possible. The opening of a township register is a very important step in the township establishment process because it benefits a string of people. We can start with the landowner. The landowner can now sell and transfer the stands in the township. The professional team who spent time on getting the township up to the state of proclamation gets paid for the services. The engineers who install the services to provide water, electricity, roads, and other services get paid for their work. The property practitioners can now sell the stands and sectional title units in the development, although the sectional title units can be sold before proclamation. The contractors can enter into building agreements with the purchasers of the stands to construct the dwelling house on those stands. The contractors who construct the buildings for the sectional title schemes get an opportunity to do what they have to do. The land surveyors who frame the sectional title plans for the sectional plan benefits from this. The bond originators, the banks who grant loans to the purchasers to purchase the stands and to finance the construction of their houses, property valuers, and then lastly, but not the least, the conveyancers who then transfer the stands, houses, and sectional title units and register the bonds linked to the transfers for these purchasers. Another party that benefits from the township establishment process is the municipality, because they now have new purchasers or landowners who have to pay rates, taxes, and for the services like water, sewage, and electricity these new owners consume. Winston Churchill once said of Russia that it is a riddle wrapped in a mystery inside an enigma. And I think for most people, this is also applicable in respect of township establishment. Most of us in the property environment may share these sentiments because we only get exposed to the end product of the township establishment process in the form of a house or a vacant stand or a sectional title unit. After all the groundwork was done to create the township. I have a very simple definition for township establishment, and I think this will work for our discussion for today. Township establishment is a process which must be followed to convert farmland into a township with stands, parks, and streets which are shown on a general plan. That takes us to the stage where the township register is open. From there, the proclamation must follow, and then there are several other steps that must be completed so that the stands in the township can be transferred and the purchase prices can be paid and people can settle in the township. I want to believe that the purpose of township establishment, apart from the money that can be made, is the creation of vibrant communities with access to facilities like schools, parks, churches, shopping centers, roads, electricity, water, and all the other necessary facilities which function so well in that specific suburb that people are keen to buy a house and settle in that suburb. This is possible in all types of township developments. In this slide, you can see a bird's eye view of the Vleerhof housing development on the west rand of Johannesburg, where this really happened. A vibrant community was created. A city which attracts many newcomers is Cape Town, both because of its drawing power and as well as the pushing power from elsewhere in the country. So there are indeed sound reasons for people who take part in this emigration to the Western Cape, where the municipalities are functioning markedly better than elsewhere in the country. I now want to take you through a process where a person decides to buy a house and explain to you the relevance of township the establishment process in the real estate market. This will also illustrate why a proper understanding of the township establishment process is important, even if a house is sold for the fifth time after the developer sold the stand for the first time back in 1937. So where does the purchaser start looking for a house to buy? The easiest way is probably the internet. In this case, our purchaser looked on the internet and he finds the website for Pam Goldie, identifies a house in Northcliffe, which he and his wife like. He phones the responsible property practitioner, and the property practitioner arranges an appointment with the seller for the purchaser and his wife to come and view the property. The address for the house is 172 Frederick Drive, Northcliffe. But please do not fret about the Protection of Personal Information Act. The information of the address of the property is essential for the marketing of the property. All other information about this property, which will be disclosed further on in this discussion, that information can be sourced from the offices of the Registrar of Deeds and the Surveyor General's office. It is available to the public if you know the correct questions to ask. Okay, the purchaser and his wife arrive at the house. They view the house. They are mightily impressed. And they are very keen to put in an offer to purchase. They also tell the property practitioner, listen, the house is so big, we consider using a section of the house for a guest house business. When they read through the offer to purchase, the following clause catches their eye. It says, the property is sold subject to all conditions and servitudes mentioned or referred to in its title deed, and to all such other conditions and servitudes which may be applicable. They have no idea at this stage which title conditions are noted against the title deed for the property. At this stage, all they know is that they like the house, they know what the street address is, and that they want to use a section of the house for a guest house. At this point, they realize that they do not have enough information about the house. They need to do more homework. And they tell the property practitioner that they're first going to check if this clause does not hold any grave consequences for them if they sign without doing a proper investigation. This is a very wise move, and it's followed up by even wiser move. They decide to phone a young conveyancer at STBB's Township and Conveyancing Development Department in Sandton and ask him to look into this matter for them. They ask him also to point out any pitfalls they can identify with regard to the status of the property and the intended use of a section of that for a guest house. In this presentation, the conveyancer is the hero. But if I must be honest, in the normal course of events for township establishment, the town planner is the hero. But please bear with me for now. The conveyancer has one lead to follow, and that is the street address of the property. So he must approach this as a case that needs to be solved. And he must use what is at his disposal. So he uses the street address and conduct a deeds office search at the deeds office, but on the street address only. This is part of the process to follow the ABC of conveyancing, which consists of assume nothing, believe nobody, and check everything. The deeds office search arrives, and this is the following information that he can see on this search. Firstly, it shows that Johannesburg is the deeds office where this property is registered. The correct description of the property is portion 1 of 523 Northcliffe Extension 2. The municipality where they will have to open a new municipal account when they take transfer of the property is the city of Johannesburg. The current purchaser bought this property for 10 million on 17 June 2002. But not only the deeds office records are relevant, the conveyancer also contacts a town planner and asks him to obtain a zoning certificate for the property, to check what the zoning of this property is, and also to check the land use scheme for the city of Johannesburg to see if it allows the use of the property for a guest house. Based on the deeds office search, the conveyancer also ordered an information copy of the title deed for the property. So the description is usually found on page 2 of the deed of transfer or the title deed, and this also relates very important information to the conveyancer. Portion 1 of 523, Northcliffe Extension 2 Township, that indicates that this property on which this house was constructed used to be part of the original 523 Northcliffe Extension 2. Shows the extent of this property as 1,425 square meters. But for the rest of the investigation, the following information is very important. It shows in the extending clause for the property that it was registered the first time by virtue of Certificate of Registered Title T39503 of 2001, with diagram SG number 3545 of 1999 annexed thereto. This means from the experience that the conveyancer already has, that portion 1 of 523 was registered for the first time as a separate entity in terms of a subdivisional diagram with number SG number 3545 of 1999. After checking the copy of the title deed, the conveyancer realizes that he needs to search a little bit further, and he obtains a copy of the subdivisional diagram SG number 3545 of 1999. And this is what he learns from this diagram. It shows portion 1 of 523, which borders Frederick Drive. And just behind portion 1, there's another portion which is marked as the remainder of 523. Another piece of information relevant to this investigation is the servitude note on the subdivisional diagram. It says that the figure A, capital A, small e, small f, capital D, represents a right-of-way servitude 6 meters wide. So, and if you look at this subdivisional diagram, this servitude area is indicated by this figure. But the investigation is not finished yet. The conveyancer realizes that he needs to go even further back into the history of this property. And he obtains a copy of the parent diagram for 532 Northcliffe Extension 2. This diagram was framed when 325 was subdivided to form 3 portions. The 3 portions are portion 1, which borders Frederick Drive, portion 2 at the back of 523, and then the middle portion, which is now known as the remaining extent of 523. This is also the portion on which the original house was constructed when the first purchaser purchased the whole of 523. It's important to also compare the cadastral information with the information that can be found in the deeds office. One other point that the conveyancer took note of is that there's a servitude that runs over the remaining extent of F523. The purpose of this servitude is to give portion 2 access over the remaining extent and also over the servitude that we saw in the subdivisional diagram for portion 1, access to Frederick Drive. In the title deed for portion 1 of 523, this right-of-way servitude is described as follows. I'm not very comfortable with the wording, how this servitude was worded in this title condition, but what the conveyancer took from this is that this servitude was created by virtue of notarial decay 1885 of 2001 S. The servitude is 6 meters wide, and in the case of portion 1, which refers to the subdivisional diagram for portion 1, it shows that it is subject to a right-of-way servitude in favor of portion 2 of F523, the back portion, and the middle portion, the remaining extent of F523. This servitude is now reflected as a title condition against the title deed of portion 1, the remaining extent, and portion 2. Which is important because that is the method or way in which these owners can exercise their rights against each other, and for the owners of the remaining extent and portion 2 can exercise their rights to access Frederick Drive. Further investigations shows a condition that prohibits the use of the property for the purpose of a guest house. Condition K reads that the earth is to be used for residential purposes only, and no canteen, restaurant, hotel, shop, factory, industry, or any business whatsoever shall be conducted thereon. This may sound like bad news to the purchasers, but the story doesn't end here. The town planner, in the meantime, obtained a zoning certificate for the property, which shows that it's zoned for residential 1 purposes. But the zoning certificate as such does not show more rights than that are shown on the certificate. That's why the town planner also had to go and check in the land use scheme. So the zoning certificate shows what the property is zoned for, and that can be either residential, business, stroke commercial, or industrial. But the land use scheme for that specific municipality reveals if this specific property may be used for a guest house. And in this case, for argument's sake, the land use scheme allows the use of the property for a guest house. Does that mean they can now automatically proceed and start a guest house business? What must they do with this title condition which restricts the use of the property to only for residential purposes? And this is a principle that is applicable. Even if it is possible to conduct the business of a guest house on portion 1 of 523, the following principles will apply. The zoning certificate does not override the title condition, and the consent by the local authority in terms of a land use scheme also does not authorize the use of the earth contrary to its registered title conditions. The conveyancer now has all the information available to give the purchaser sound advice on the property that they want to purchase. So in the report, the conveyancer states, the house is on a stand which forms part of 3 subdivided portions. There are 2 stands behind the house, and those owners will have to drive past the house on portion 1 to reach Frederick Drive, and also when they return to their homes. The stand is subject to a servitude to allow the owners of the 2 stands behind it access to Frederick Drive, and it's noted against the title deed as a title condition. The zoning and land use scheme allow the use of the property for a guest house. But there's a title condition which prohibits the use of the house for the purpose of a guest house. Now, what is the solution? If the purchaser wants to use the property for guest house purposes, this restrictive title condition K must be cancelled in terms of the municipal planning bylaws or other relevant legislation, so that it can be removed against the title deed for portion 1 of 523. You may ask, what on earth does this all have to do with township establishment? And the answer is everything. Township establishment does not end with the proclamation of the township. After the township has been proclaimed, it is possible to subdivide the stands in the township. Portions of streets can be closed to form new stands, which can be consolidated with adjacent stands, form bigger stands. Servitudes can be registered. Consolidations can be registered. Adjacent stands can be consolidated into one bigger stand, or any number of stands for that purpose. Also, the zoning of the stands in the township can be amended with rezoning applications. We now know what happened to 523 after Northcliffe Extension 2 was proclaimed. But the plot thickens. Will you believe me if I say that we can trace back the history of 523 to 7 March 1898. Before we get to that, just understand how that can happen. When Northcliffe Extension 2 was established, a landowner owned farmland which was suitable for township establishment purposes. He appointed a professional team who needed to make the township establishment possible. Then the input of government departments was required in their response to this township application on a municipal level, provincial level, and on a national level. When this specific township was established, public participation was not part of the process. But nowadays, the public can respond to a township application, and they are part of the whole process, from the environmental part, as well as the publication for comments of the township application. The Office of the Surveyor General had to approve diagrams and the general plan for the township. The Deeds Office had to open the township register, and then the government printer had to publish the proclamation notice. Let us look at the general plan for Northcliffe Extension 2. This is an old township. I think this township was approved, this general plan was approved in 1937. But what is important is that if 523 was created on this general plan for the first time. You cannot see it now clearly, but this general plan shows stands and streets and parks. If we zoom in on the portion of the general plan where 523 is situated, we can see this much clearer. So there's a whole of 523, not yet subdivided. There's Frederick Drive, and here are adjacent stands. So that's the position of 523 on this general plan. The general plan gives another clue to follow the history of 523. If you look at this section on the general plan, it shows that This township was established on the farm Aasvogelkop 201 IQ. And the land on which it was established is presented on diagram number A4133 of 1937. And the title deed was a certificate of consolidated title. So our next clue to follow is this diagram. We go to this, we find this, this conveyancer, and us looking at this presentation can now follow the next step in this process to trace the history of a 523. This is the diagram for the farm Aasvogelkop. It's quite a huge tract of land, and there are notes on this consolidation diagram which gives more information about how this farm was formed. So the next clue leads us to the 5 components which were consolidated to form the farm Aasvogelkop. They are listed under notes, and the figures are described so that you can go back and plot those 5 farm portions on the diagram for the farm Aasvogelkop. But we haven't been able to track exactly where a 523 lies on the farm portion. Very simple way to do it is find a 523 on the general plan, and then the corresponding position on the consolidation diagram or the diagram for the farm on which Aasvogelkop was created. And then you will know on which farm this earth has its origin. In the township and the development conveyancing department, we pride ourselves on going the extra mile. You may be familiar with the book, The Road Less Traveled by M. Scott Peck, but we follow a different book in this department. We follow the road most traveled, and that is the road where we go the extra mile for the client. The conveyancer took it one step further with his research on the origins of this township and the earth on this township. Many years before the land on which North of Extension 2 was established became farmland, it was inhabited by wild creatures. And as part of the conveyancer's research, he was able to establish that a pride of lions caught a buffalo on 7 March 1898 on the exact spot where portion 1 of Earth 523 is situated. He unfortunately could not determine the exact time of day, but he said it was during daytime that this happened. In summary, township establishment goes further than just the proclamation of a township. And the significance of this for the real estate market is that the source of new housing stock is not only the establishment of new townships, but also the further township establishment process that takes place after proclamation, with the subdivision of stands, street closures, rezonings, consolidations, and registration of servitudes. But what is even more important is a proper understanding of the township establishment process. We do not have time today to go into the nitty-gritty of the township establishment process. But if you're interested, we can address this in future webinars. Just for you to understand the different phases for the township establishment process that leads up to the proclamation of the township, and which will be addressed in another webinar, is There's a research phase to determine if the land is feasible to establish a township on that. Then there is a planning phase or consideration phase. Consider all the available factors and information that may impact on the possible township establishment. Then there is a preparation phase to submit the township application and the motivating memorandum to the municipality. Then there's a submission, publication of the notice for and the circulation of the township application phase. When this phase starts, there's a period where responses to objections, comments, and representations are received and dealt with. After that, the municipality can take a decision on the township application. And if the township application is not approved, there are objectors, the application will be heard at a tribunal hearing. If there are no objectors, the township can be approved by the municipality, and then the compliance and implementation phase can start. I hope you enjoyed connecting the dots to where township establishment fits in the real estate market. May you never look again at a house for sale without remembering the blood, sweat, and tears which produced this product to the housing market. I know that this discussion did not deal in too much detail with all the steps of the township establishment process, but it's just too vast a subject to address in one webinar. If you want us to tackle any of these topics or any other aspect of township establishment, please let us know, and then we can do that. Thank you.
Thank you so much, Gert, for the wealth of knowledge on the town establishment process. I'm sure everyone found that exceptionally interesting, and just understanding the ins and outs of township establishment, which I don't think is always shared very often. So just a few questions from the chat is. And I'm hoping I hope I'm pronouncing this name correctly, but Karaja asked if there's any way to check the zoning rights of a property without using a town planner.
Yes, one can do that yourself. You can approach the municipality, but I believe in horses for courses. It will be worth your while. Town planners have an established relationship with the officials at the municipality, but nothing prevents a person from approaching the municipality and requesting the zoning certificate for that for a property.
Great. And then she also asked, as well as, who is the company that the title deed is referring to? And I think that was a specific segment that you were busy with in your presentation.
The question is, to which company that the title condition referred to?
Yes.
Which prohibit the use of the property for the purpose of a guest house.
Yes, that term company, who does that refer to?
That company is defined in the title conditions. It's usually the township owner, or the township owner or township applicant who introduced a clause like that, to make sure that the nature of the township is managed and doesn't change from its original planning. So, and many times those original township companies, they've been liquidated. After they completed the township establishment process, they are no longer in business. And that's why you then need to approach the municipality with an application to remove the title deed. If they are still in business, that company can be approached directly and request their permission. But the correct way is to get that title condition cancelled in terms of the SPLMA bylaw.
Thank you. Then Daniel asked if there's a difference between cadastral and registered land size.
No, the deeds office follows the records the Surveyor General's office. So if that subdivisional diagram indicated the extent of that portion 1 of 523, and that was exactly that needs to be carried forward to the title deeds, and that's also on which the deeds office base their records, the records of the Surveyor General. Trust me, there are nowadays discrepancies between those two sets of information because of matters getting incorrectly captured on the data. You might do a deeds office search, and the data may information may be different to what's in the title deed and on the diagram for the property. So yes, the long answer, the short answer, which I answered for the long answer, is the record of those two offices must correspond.
Okay, because yes, please, Daniel, maybe you can just phrase your question differently to her directly.
Hi, Gert. Okay, so it's Tennille. I think my question basically is, when you do like a Lightstone report, for example, it'll give you a cadastral and the registered land size. Most of the time, those two sizes are very different. Well, not very different, but they definitely are few square meter, or I think it's square meters different in size. So is there a difference between cadastral and registered? Which is the more accurate measurement?
I will put my faith in the cadastral information of the Surveyor General, because you can go back and check it and see that the extent of the property is given on that a diagram for that property, while the deeds office, their records follow what's on the cadastral information. And especially with deeds office searches, sometimes they do make a mistake with the extent. All the properties which are still reflected in Morgan, that happens quite a lot of those type of properties when it's not metricated already. But you trust the cadastral information. I feel bad to say that as a former deeds office official, but that's the best way to deal with that.
Okay, Daniel, does that answer your question, or was there any follow-ups on that? Okay,
no,
great.
That answers my question. Thank you.
Perfect. Then Cassandra asked, where does one obtain the land use scheme information form?
The land use scheme is available. The City of Johannesburg's got its own land use scheme, which they've published. So you just need to access that. You can get it from the internet, and that will show you the zoning certificate shows the primary use of the property, but you'll find secondary uses which can be granted in terms of consents by the municipality in the land use scheme.
Okay, great. Then I see there's a question also from Diana, and she says would love to hear more detail on the smaller scale. If a PP sells a piece of land, say 8 acres, to a potential developer of a townhouse complex, what is necessary to be done? What steps will need to be taken to ascertain whether consent from development is likely or unlikely to be granted?
Before development is started, a proper due diligence must be done, and that will require input from various professionals. The land conditions need to be examined, the title conditions, the cadastral information. So let me just talk from a conveyancer's point of view. What we do with a new development is we prepare a conveyancer certificate which identifies all the title conditions applicable in respect of the properties which will be affected by the development. We also then need to check if those title conditions are noted correctly, because we really pick up very often now that some title conditions get left out or incorrect title conditions are recorded. So you need to get the correct picture. So we work in tandem with a land surveyor who then does a servitude certificate. He identifies all the servitudes that are registered already against the title deed, and also all the servitudes for which servitude diagrams have been approved at the office of the Surveyor General, but those servitudes have not been registered yet in the records of the deeds office. And all of that information is needed by the town planner to plan the layout of the township. This is a very long question to answer, and that can be done in 3 webinars, but not immediately after each other.
Okay, thank you. And then Roxanne asked if there is a servitude reflected on the subdivisional diagram, but no reference to the servitude on the said title deed conditions, what can be done to rectify the position or the title deed?
If that servitude was supposed to be registered against that title deed and it was missed by somebody, it must be registered now. It can also be that if it's a subdivision which hasn't been registered yet and the servitude is reflected there, that servitude can then be registered when that title deed for that new subdivision is created. So I hope that answers the question.
Great. I think that is all the questions that I could see. If there's anyone else that still has any questions that they would like to ask. We still have a few minutes. So, okay, so I think that then is everything. Gert, so thank you so much for today's session. I think it was exceptionally informative. And thank you everyone for joining today as well. We would love to get your feedback on this webinar, and then you're also more than welcome to always send us some queries, and to Gert as well if you have any other questions regarding township establishments and town planning and so on that he can help you with. So thank you everyone. We will be sharing the recording afterwards, so you can also have a listen to it again if there were some things that you missed. So thank you everyone, and have an absolutely amazing week. And I'm sure, well, this is the last webinar from STBB side, so I'm hoping we see you all next year for all of our presentations and webinars. Thank you, Gert, and goodbye.
Thank you, bye-bye.